greatest weapon of all.
First step in solving any problem is recognizing there is one.
It's time we started talking. Pain isn't something we talk.
All we can ever do for our heroes is remember them when they gave up two lives, the one they were living and the one they would have lived. They gave up everything for our country, for us. They pray for freedom and justice.
Some veterans not getting the timely care that they need. Less than 1% of Americans serving in uniform. Good news is that in recent years we've made historic investments to boost the VA budget.
What is it? Why should we care?
We should care about press freedom
because we were informed.
In democratic societies, free, diverse, and pluralist media enable public debates and are essential checks
You don't
on
look
power.
satisfied. Let's discuss.
Hey guys, welcome to Vet the Vet podcast episode 16, season 3. If this is your first time listening, thank you for coming and checking this out. With me is my buddy.
What's up, guys? My name's Ernie Treviso. I'm a friend of Joe's. He helped me understand the VA processes, and now that I'm a little bit more familiar with it, I'm paying it forward and helping him out. So hopefully you guys enjoy this next podcast.
Yep. So we're talking about military diversion. So veterans and active duty military personnel suffering from trauma or mental health issues may be eligible for military diversion in lieu of jail time in California.
So the military diversion was established in January 2016. And it was a pretrial program for current or former members of any branch of the United States military charged with misdemeanor crimes. Regarding eligibility, the court must find that these defendants may be suffering from sexual trauma, traumatic brain injury, post-traumatic stress disorder, substance abuse, or mental illness as a result of their military service. This is a collaborative program of the Probation Department in San Mateo County Superior Court, Private Defender Program and District Attorney's Office, and the Department of Veterans Affairs. Participants attend court, review hearings, and work towards successful completion of the program by completing counseling and or treatment and full payment of victim restitution. Upon successful completion, participants' charges are dismissed. To date, there have been at least 15 individuals that have graduated from the program.
So let's get into how this stuff works. So military diversion is a form of pretrial diversion and is authorized by California Penal Code 1001.80. This penal code allows judges to postpone criminal proceedings for misdemeanor crimes while the defendant obtains treatment for PTSD, sexual trauma, TBI, substance abuse, or other mental health problems. Dismissal of criminal charges after military diversion. Upon successful completion of military diversion program, the charges against the defendant will be dismissed. The rest will be deemed never to have occurred for most purposes. If asked about his or her criminal record in an interview for a job other than a peace officer, the defendant will not need to disclose the arrest or diversion.
Now, who's eligible for this military diversion? To qualify for military diversion, both of the following conditions must apply. First, the defendant was or currently is a member of the United States military. And two, as a result of his or her military service, the defendant may be suffering from PTSD or one of the other conditions listed above.
To help you better understand the military diversion and PTSD as a defense to criminal charges, our California criminal defense lawyers discuss these issues below that we'll get into.
So what is military diversion under California Penal Code 1001.80? Military diversion is a special type of pretrial diversion. It is available as an alternative to jail time in a California misdemeanor case against veterans or active members of the military. Defendants do not have to plead guilty or no contest in order to obtain diversion under PC 1001.80. Rather, the judge will postpone proceedings while the defendant participates in a program of treatment and education. Upon successful completion of the program, the charges against the defendant will be dismissed. If the defendant does not complete the program, the criminal charges will proceed and will resume. California also offers a similar mental health diversion program whereby participants can also get their charges dismissed and criminal records sealed.
So what conditions qualify someone for military diversion? Defendants may qualify for military diversion if, as a result of their military service, they suffer from PTSD, military sexual trauma, traumatic brain injury, substance abuse, or other mental health problems. The problem must, however, have arisen as a result of the defendant's military service. Moreover, the diversion is usually only available for first-time offenders. Defendants with a prior conviction for the same offense will usually be referred to Veterans Court, discussed in Section 4 below. Veterans Court provides a higher level of structure and supervision than military diversion.
So, what is post-traumatic stress disorder, or PTSD? So, PTSD is a mental health condition experienced by some people who have been through a traumatic experience, such as combat or a sexual assault. Not everyone who experiences trauma develops PTSD. Some people go through a difficult time, but snap back fairly quickly. Others have a very serious symptom that lasts a few weeks. This is called acute stress disorder, or ASD. When symptoms do not go away, however, the person may be suffering from PTSD. Such a diagnosis should be considered when symptoms last more than a month, are seriously affect one's ability to function, and are not due to substance abuse, medical illness, or anything except the traumatic event itself. And what are these symptoms of PTSD? Well, they typically begin with 3 months of traumatic incident, but begin years later. Diagnosed with post-traumatic stress disorder, an adult must have all of the following for at least 1 month. At least one re-experiencing symptom, at least one avoidance symptom, at least 2 arousal or reactivity symptoms, and at least 2 cognition and mood symptoms. Re-experiencing symptoms include flashbacks, bad dreams, and or frightening thoughts. Staying away from places, events, or objects that are reminders of the traumatic experience, and or avoiding thoughts or feelings related to the traumatic event. So arousal and reactivity symptoms include being easily startled, feeling tense or on the edge, having difficulty sleeping, and or having angry outbursts. Cognition and mood symptoms include trouble remembering key features of traumatic events, negative thoughts about oneself or the world, distorted feelings such as guilt or blame, and or the loss of interest in enjoyable activities.
Risk factors for PTSD. It is normal for people to experience a certain degree of fear and anxiety after a traumatic event, but most people who experience trauma will not develop PTSD. However, some people appear to be more at risk for developing PTSD after a traumatic event. These include women, people who experience childhood trauma, people with little social support, people with a history of mental illness or substance abuse, and people who have recently experienced another source of stress such as a loss of a job, home, or loved one. Military sexual trauma. The definition of military sexual trauma used by the U.S. Department of Veterans Affairs is set forth in the 38 U.S. Code 1720D and defines military sexual trauma, MST, as psychological trauma which in the judgment of a VA mental health professional resulted from a physical assault of a sexual nature, battery of sexual nature, or sexual harassment which occurred while the veteran was serving on active duty for training, or inactive duty training. Sexual harassment is further defined as repeated unsolicited verbal or physical contact of a sexual nature which is threatening in character. Acts that fall within this scope of military sexual trauma include without limitation rape, forced oral copulation, penetration with an object, sexual battery, groping, coerced sex, threatening offensive remarks about a person's body or sexual activities, and threatening and unwelcome sexual advances. It does not matter whether the service member was on or off duty or on or off base at the time of the assault or harassment. If the experience occurred while the service member was on active duty or active duty for training, the VA will consider it MST.
So now, what is traumatic brain injury, or TBI? TBI is a type of cognitive impairment resulting from a violent blow or jolt to the head or body. It can be caused by a serious fall of an object, such as a bullet, penetrating the brain tissue. Explosive blasts are also a common cause of traumatic brain injury in military personnel. Researchers believe that the pressure wave passing through the brain significantly disrupts brain function. Traumatic brain injury also results from penetrating wounds, severe blows to the head with shrapnel or debris, and falls or bodily collisions with objects following a blast or vehicle accident. Some symptoms of the TBI are numerous. They can include physical symptoms such as headaches, dizziness, and loss of coordination or sensation, as well as cognitive and emotional difficulties. These symptoms may appear immediate after the traumatic event, or days or even weeks later. The cognitive and emotional problems can be a source of tremendous frustration and conflict for military members and their families. They may also lead to mental health problems such as depression or substance abuse, as the afflicted individual tries to cope with his or her symptoms. Long-term issues associated with TBI can include, but are not limited to, problems with memory, learning, reasoning, judgment, attention or concentration, problem solving, and decision making, organization and planning, beginning or completing a task, language and communication, self-control, depression, anxiety, irritability and or mood swings, anger and insomnia.
Substance abuse and other mental health problems. In addition to people suffering from PTSD, sexual trauma, or TBI, military diversion is available to people suffering from substance abuse or other mental health issues, including severe depression. The key question for the court is whether the condition resulted from the defendant's military service and whether the defendant would benefit from treatment. What offenses qualify a defendant for military diversion? Military diversion is available if otherwise eligible defendant is accused of a misdemeanor crime. Common misdemeanors affecting veterans include but are not limited to DUIs, possession of narcotics, and misdemeanor assault and battery.
Now, how does a defendant get military diversion? Usually the defendant's California criminal defense lawyer will request diversion from the court. The court may or may not then request an assessment to help it make a determination. If the court agrees if the court agrees that the defendant qualifies and provided the defendant consents, the defendant will then be placed in a pretrial diversion program. Criminal proceedings will be postponed for up to 2 years while the defendant receives treatment.
What treatment programs can the defendant use? The court will assess whether the defendant should be ordered to participate in a federal or community-based treatment service program. Preference will be given to treatment programs with a history of successfully treating individuals who suffer from trauma due to their military service. Such programs may include but are not limited to programs operated by the United States Department of Defense or the United States Department of Veterans Affairs. The court and the assigned treatment program may collaborate with the Department of Veterans Affairs and the United States Department of Veterans Affairs to maximize benefits and services provided to the veteran. If mental health treatment services are ordered, the court may also refer the defendant to the court mental health authority, provided the agency agrees to accept the responsibility for all of the following: the treatment of the defendant, the coordination of appropriate referral to county veteran service officer, and the filing of reports to the court.
So now, are there any other conditions for the participation? Well, the defendant must comply with any and all conditions imposed by the court or the assigned diversion program. Such conditions may include attendance at treatment sessions, counseling for domestic violence and or substance abuse as appropriate, random alcohol and or drug testing, and satisfactory progress reports for the agency administering the program. The agency or agencies responsible for the program will provide the court and the prosecutor with reports on the defendant's progress no less frequently than every 6 months. Now, how long will this treatment last? Typically, military diversion programs last 12 to 24 months. By law, the period during which criminal proceedings against the defendant may be diverted shall be no longer than 2 years.
Can the court terminate military diversion before I complete it? The answer is yes. The responsible agency or agency shall file reports on the defendant's progress with the court and with the prosecutor not less than every 6 months. The court may hold a hearing at any time if it appears to the court that the defendant is performing unsatisfactorily in the assigned program, or the defendant is not benefiting from the treatment and services provided under the diversion program. If the court determines that the treatment is not working, it may terminate the diversion and resume criminal proceedings against the defendant. Will my arrest record be sealed if I complete military diversion? Upon the defendant's satisfactory completion of the program of treatment, the criminal charges against the defendant will be dismissed. No record of the arrest or diversion may then be used without the defendant's consent in any way that could result in the denial of an employment, benefit, license, or certificate. The defendant can truthfully indicate in response to a question concerning his or her prior criminal record that he or she was not arrested or diverted for the offense.
So, exception. Application to become a peace officer. The one time the defendant must disclose the arrest is if he or she applies to become a peace officer. In such a case, it must be disclosed in response to a direct question contained in a questionnaire or application for a position as a peace officer. Additionally, the record may be disclosed by the Department of Justice in response to a peace officer application request. So now, will my driver's license be returned if I was arrested for DUI? Not necessarily.
So thank you guys for listening. Hopefully you guys get something out of this. And I want to appreciate Ernie for helping me out with this podcast. And we're just going to show off what my buddy can do.